Okay, let's unpack this. Did you know that the powerful, articulate dissenting opinions we hear from Supreme Court justices today are, well, actually a relatively modern invention?
It's surprising, isn't it?
Yeah. For much of its history, the court operated with surprisingly little open disagreement among the justices.
Very little.
Today, we're taking a deep dive into the fascinating and I think increasingly urgent evolution of Supreme Court dissents, especially from its liberal justices, Lena Kagan, Sonia Sotomayor, and Ketanji Brown Jackson. We'll explore what these sharp, sometimes defiant dissents are really trying to tell us about, well, the state of American law and maybe even democracy itself.
And what's truly striking here, based on our sources, is that these aren't just, polite disagreements on technical legal points.
Right.
Our mission in this deep dive is to understand how these dissents signal a fundamental shift in how these justices perceive the court's operations. It reflects a belief, according to the analysis we've looked at, that the old game of law simply isn't being played anymore.
The old game. We've pulled insights from recent legal scholarship and analysis, including articles dissecting Justice Kagan's evolving dissent strategy and some broader critical perspectives on the current judicial climate.
Should be some interesting points to discuss.
Definitely. So, to really grasp the magnitude of these modern dissents, maybe let's first set the stage with some historical context.
Good idea.
It's truly eye-opening, I found, to look back at Chief Justice John Marshall's early tenure. Almost no dissents at all back then.
That's right. In his first 4 years, I think the stat is only one single-sentence concurrence and 0 dissents.
0. And it wasn't really until the mid-20th century that dissenting really took off. Something like 70% of cases before 1928 had neither a dissent nor a concurrence.
A very different court dynamic.
So what drives a justice to dissent then, especially given this historical, maybe, reluctance?
Yeah, that's a great question. If we connect this to the bigger picture, justices choose to dissent for various reasons, both strategic and personal. Chief Justice Charles Evans Hughes, he famously described a dissent as an appeal to the intelligence of a future day.
The appeal to the future.
Exactly. When a later decision may possibly correct the error, it's kind of playing the long game, essentially.
But are there more immediate goals, like practical reasons for a justice writing a dissent right now? Are they always hoping to overturn the decision eventually, or are there other aims?
Oh, absolutely. More immediate aims, too. Dissents can be used strategically to, say, force the majority to maybe narrow its holding, make it less sweeping.
Okay.
Or they might aim to propel legislative change, get Congress to act. Sometimes there's even talk of judicial log rolling, trading votes, maybe, though that's harder to prove. But definitely, dissents can serve to organize external activists, get media coverage for a viewpoint, guide state courts, or simply keep a legal doctrine sort of simmering alive until maybe a more favorable court comes along.
And this raises an important point you mentioned earlier, this idea of legitimacy. How do dissents help with that?
Well, they can highlight that the court didn't just reach a decision lightly, that there was genuine deliberation, different views considered.
Right.
It reassures the public, potentially, that disagreement is heard, that the court isn't just a monolith. Even if you dislike the outcome, seeing a strong dissent shows the process,
Makes sense. So our sources categorize dissents into, I think, 3 main types, though they can overlap. Can you walk us through those?
Sure. First, you have what are called collaborative dissents.
Collaborative. How does that work in a dissent?
Well, it means the justice tries to work within the majority's own logic, its own stated principles. They basically say, okay, I accept your premise, but you've misapplied it here.
So fighting them on their own ground, sort of.
Exactly, pointing out inconsistencies in their application. Then second, there are mobilizing dissents.
Okay, that sounds more outward-looking.
It is. These target external actors, the public, activists, lawmakers. The goal is to shape public narratives, build momentum outside the court.
Any famous examples?
Well, the sources point to dissents related to Roe v. Wade that helped galvanize anti-abortion activism over decades, and dissents in cases like Sierra Club v. Morton that arguably empowered the environmental movement.
Got it. And the third type?
Perpetual dissents. This is where a justice or justices just keep dissenting on the same issue, case after case, year after year, even after it's supposedly settled law.
They just won't let it go.
Pretty much. Think of Justices Brennan and Marshall on the death penalty. They dissented in hundreds of death penalty cases, arguing it was always unconstitutional.
Wow.
And a more recent example the sources give is Justice Scalia's constant dissents in abortion cases. That persistence, you could argue, laid groundwork for the eventual overturning of Roe and Dobbs.
So that could be strategic, institutional, or just deeply personal conviction.
All of the above, often. A focused effort to overturn precedent, or maybe a belief that their oath requires them to stick to their own constitutional interpretation no matter what.
Okay, let's shift focus now to individual justices, because Justice Elena Kagan's career provides a really fascinating case study here. She was known for a long time as a consensus builder, right, even before the court. In the Clinton administration, as Dean of Harvard Law, famous for careful diplomacy.
That's the reputation, absolutely. Resolved a big standoff at Harvard Law School. And even on the court initially, building relationships. Didn't she famously go hunting with Justice Scalia?
She did.
Yeah.
Which speaks volumes about trying to bridge ideological divides personally.
So how did that consensus-driven approach show up in her early judicial strategy?
Well, her early strategy, according to the analysis, was quite pragmatic. She'd often offer her vote to the majority, but in exchange for, say, narrowing the question presented or tweaking the language.
Leadership bargain. Essentially, yeah. Trying to minimize the impact of a ruling she might otherwise disagree with more fundamentally. The Masterpiece Cake Shop case is cited as an example where she joined the majority, but likely worked to limit its scope.
Right. The baker and the wedding cake.
Exactly. And in Trinity Lutheran, another case involving religion, it suggested she extracted a key footnote to narrow its impact on funding religious institutions. It was about making incremental gains, or maybe limiting losses at the margins.
But then things changed. That strategy seemed to become less effective, particularly after Justice Kennedy left. He was often the swing vote, right?
Absolutely. His departure in 2018 and replacement by Justice Kavanaugh shifted the court's balance significantly.
And Kagan herself commented on that, didn't she? Lamenting the loss of swing justices who made the court seem, in her words, impartial and neutral and fair.
She did. She worried publicly about the court's legitimacy without that moderating influence in the middle.
Do the numbers back up this shift in her own position? Fewer agreements, more dissents?
Oh, definitely. The quantitative data is pretty stark. Justice Kagan's time in the majority, it dropped from an average of about 89% in the terms from 2012 to 2016.
Okay, pretty high.
Down to 76% in the 2017 to 2021 terms. And her authored dissents, they jumped significantly. She wrote 17 in her first 7 years.
Right.
Then the 30 in just the 5 years after Justice Gorsuch joined. And get this, she's written almost as many dissents, 20, in the 3 years since Justice Barrett joined, as she did in her entire first 8 years on the court when she wrote 21.
Wow, that's a dramatic increase. And what about the intensity of those dissents?
That ramped up, too. She started reading dissents from the bench.
Which is a big deal, right? Not common.
It's a very strong signal. It means the dissenter thinks the majority isn't just wrong, but like grievously wrong. She did it first in 2011, then again in 2017 and 2018. And she apparently said she would have done it more if the pandemic hadn't stopped in-person readings for a while.
Let's look at a few specific cases our sources highlight to see this evolution. Maybe start with that first bench dissent.
Okay, yeah. That was Arizona Free Enterprise Club's Freedom Club PAC v. Bennett in 2011, a campaign finance case.
Right.
And here she delivered what the analysis calls a collaborative dissent. She argued the majority misapplied its own precedent about speech restrictions versus subsidies.
So working within their framework still.
Exactly. But the language was notably accessible. Eminently quotable, as one source put it. It had elements of a mobilizing dissent, too, trying to reach a broader audience.
Okay, fast forward a bit. What about Rucho v. Common Cause in 2019? This was after Kennedy left.
Yes, the partisan gerrymandering case. The court basically said federal courts can't rule on partisan gerrymandering claims. They're political questions.
And Kagan's reaction?
Fierce. She called the decision tragically wrong. Said it deprived citizens of a fundamental right to choose their government. This was described as a radical dissent because it felt like she was saying the majority had abandoned core democratic principles, shared values.
Did she end it quite emotionally?
Reportedly, yes. She concluded, "With respect but deep sadness, I dissent." And her voice apparently vibrated with emotion. This definitely became a mobilizing dissent, cited later by state courts trying to tackle gerrymandering under state law.
And she hasn't let go of Rucho, has she?
No. She later said there's no part of me that's ever going to become accepting of it. That sounds very much like laying the groundwork for a perpetual dissent.
Okay, one more. Brnovich v. Democratic National Committee in 2021. This was after Justice Ginsburg passed away.
Right. This involved challenges to Arizona voting restrictions under the Voting Rights Act, the VRA.
The court upheld the restrictions.
In Kagan's dissent here, palpable anger is how one source described it. She accused the majority of essentially rewriting the VRA to weaken it, of enabling voter discrimination under the guise of election integrity.
Did she use any particular tactics in that dissent?
Interestingly, yes. She leaned heavily on textualist arguments, focusing strictly on the law's text, which is often seen as a conservative methodology. She used it, the analysis suggests, to highlight what she saw as the majority's hypocrisy, their departure from their own preferred methods when it suited them.
And was this also a mobilizing dissent?
Definitely seemed intended to be readable, motivating, and notably, she later referenced this Brnovich dissent in another case, suggesting she might pursue a perpetual dissent even on a statutory case, which is pretty unusual. Usually perpetual dissents are about constitutional issues.
And this trend just continues. I mean, just recently in 2024, another dissent where she called out a power grab by the court regarding agency deference.
Right, excoriating the majority, again, for not following its own supposed rules.
So Kagan's evolution is clear. But she's not alone in this, he said. Justices Sotomayor and Jackson are also issuing these defiant dissents. How are they adding to this critique that the old game is over?
That's right. It's not just Kagan. Sotomayor and Jackson are contributing powerfully, though maybe with slightly different emphasis. But the overall message, as interpreted by the sources, seems unified. The court, in their view, isn't playing by the traditional rules anymore, that the majority seems, quote, unbound by law and its tiresome technicalities.
So different voices, same underlying concern.
Exactly. They critique incoherence, factual issues, but each brings a distinct focus to why it matters.
Let's dig into those unique contributions. Justice Sotomayor, for instance, the sources suggest she often highlights the court's perceived complicity in wrongdoing.
Yes, that's a key theme identified in her dissents. A stark example is from United States v. Higgs, a death penalty case. Instead of just dry legal argument, she began her dissent by listing the names of 13 men recently executed, arguing it happened without proper orderly process.
Wow, starting with the names.
Yeah, very powerful. She warned this is not justice. It was a deliberate move away from cold formality to underscore the human stakes, the real-world consequences.
And more recently,
just weeks ago, actually, in a case about blocking a presidential executive order with a nationwide injunction, she warned that no right is safe if the majority rewards what she called gamesmanship. She directly accused her colleagues of closing its eyes to non-compliance.
that sounds incredibly blunt, calling out her colleagues directly like that.
It really is. That kind of candid expression of distrust is a significant departure from the usual norms of collegiality on the court.
Okay, and what about Justice Jackson? As the newest justice, what's her distinct approach, according to the analysis?
Justice Jackson's focus seems to be on situating legal wrongs within the broader social and political context. She argues that judging isn't just an abstract exercise. It happens against and within the world.
Can you give an example of that?
A major one is her dissent in Students for Fair Admissions v. Harvard, the affirmative action case. She wrote very plainly about gulf-sized race-based gaps. She used a hypothetical imagining two college applicants from North Carolina, John and James, to meticulously trace how historical and ongoing racism creates an almost inevitable gulf between the opportunities available to black and white applicants.
So making the systemic issues concrete.
Exactly. She argued the majority's ruling cuts into the abiding wounds of our racialized past, making the connection impossible to ignore.
And you mentioned another case about birthright citizenship.
Yes, technically the case was about the procedural issue of nationwide injunctions, but the underlying policy involved birthright citizenship. And in her dissent, she described the administration's effort, the one being challenged, as an existential threat to the rule of law. She used the word lawlessness 8 times.
8 times, that's emphatic.
It really is. And this is where it gets particularly thought-provoking, as you mentioned. In a footnote in that dissent, she explicitly brought up the dual state theory.
Ah, yes. Drawing parallels, the sources say, between aspects of Trump's America and 1930s Germany. That sounds intense.
It is, and it showed, according to the analysis, her deep understanding of law, not just as isolated rules, but as an integrated system, and what happens when that system starts to break down.
Okay, we have to talk more about this dual state concept. It sounds chilling. Where does it come from?
It is chilling, and it's a really key insight from the source material we looked at. It originates with a man named Ernst Frankl. He was a Jewish labor lawyer in Berlin in the 1930s who managed to flee the Nazis in 1938.
And he wrote about his experiences.
He did. He wrote a book called The Dual State, a contribution to the theory of dictatorship.
The dual state.
Yeah.
Okay, what was his core idea? He said it wasn't just that the Nazis destroyed the legal system.
Exactly. That's the crucial point. Frankl observed that a dictatorship doesn't necessarily just erase the existing legal system overnight. Instead, it does something more insidious. It maintains what he called a normative state.
The normative state.
Yeah, basically the realm of stable, predictable rules and procedures. You need those to keep things running, like the economy, contracts, and day life. But alongside that...
Here comes the second state.
Right. Alongside it, the regime creates a parallel prerogative state. And this is a zone of essentially unlimited arbitrariness and violence, unchecked by any legal guarantees.
So two systems operating side by side, one with rules, one without.
Precisely. And in the prerogative state, legal actors, judges, police, officials, they defer to the regime's will, not the law. The really insidious part, Frankl pointed out, is how these two states coexist uneasily. People, cases, situations can be suddenly jerked, as he put it, from the normative state where they thought they had rights.
Into the prerogative state where rules don't matter.
Exactly. Frankl saw it happen himself. As a Jewish lawyer who was initially allowed to practice because he'd served in World War I, he'd win a case for a client in the normative legal system, only to see the Gestapo waiting outside the courtroom to take them away into the prerogative state, like to Dachau.
That's terrifying. So what's the connection the sources are drawing to the present day? Why invoke this now?
Well, the aha moment, according to the source material, is using Frankl's framework as a lens. The argument presented in these sources is that we might be seeing, or perhaps witnessing the beginnings of, a new kind of dual state emerging in the U.S., particularly associated with the Trump administration and its allies.
How so? What specific things are they pointing to?
The sources cite things like pardons that seem to encourage lawlessness or insurrection, efforts to purge career civil servants, lawyers, inspectors general who weren't seen as loyal enough, demands for personal loyalty over constitutional oaths, and frequent verbal attacks on judges and the justice system itself.
And the argument is that these actions are designed to what?
To carve out a space, a domain, where the normal rules of law don't apply to the leader and their allies. To create a zone where, as Frankl might put it, cruel caprice, not law, rules.
Now, the sources are careful to say the scale isn't comparable to Nazi Germany.
Absolutely. Critically important caveat. The extent of displacement of law isn't comparable yet. But the pattern of rejecting basic constitutional norms and legal constraints is what they find striking and reminiscent of Frankl's analysis.
And the danger isn't necessarily full-blown fascism, but targeted suppression.
That's the idea. A dual state doesn't have to end in genocide. It can simply mean that certain groups or individuals are subject to arbitrary power, while most people carry on in the normative state, perhaps ignoring the danger until it affects them.
Because Frankl warned that once the prerogative state is built,
it can swallow anyone. That's the chilling warning. So Justice Jackson invoking this theory, the sources argue, isn't just academic. It's a profound warning about the potential trajectory.
Okay, so understanding that context adds a lot of weight to these dissents. Let's bring it back to Justice Kagan. Her aims in dissenting seem to have evolved quite a bit. What's seen as her core motivation now?
Well, her core motivation, as highlighted in the analysis, seems to be this fight for the court to act like a court.
Act like a court. What does that mean in practice?
Primarily, it means abiding by precedent, stare decisis. She sees adherence to precedent as absolutely crucial, a bastion of legitimacy, she's called it. It's what keeps the court looking like a court of law, not just politics. It moderates ideological swings, reassures the public.
Then she's expressed concern about jurisprudential whiplash, right? When the court changes course too quickly, especially with new members.
Deep concern. She worries that when new justices arrive and quickly overturn long-standing principles, it makes the court look like it's just about, quote, people with one set of policy views replacing another.
And that damages the court's standing.
Hugely, in her view. It harms its reputation, its legitimacy in the eyes of the public, and potentially its ability to function effectively and protect fundamental rights down the line. A court seen as purely political might lose the public trust needed to enforce even its most important decisions.
So when we see these increasingly sharp, unified dissents from Kagan, Sotomayor, Jackson critiquing incoherence, twisting facts, ignoring precedent. It's not just sour grapes about losing a case.
Not according to this analysis, no.
Yeah.
It's much deeper. They're signaling what they perceive as a crisis of legitimacy for the court itself.
But let's be realistic. Do these dissents actually change the law, historically speaking?
Well, that's the tough part. History suggests it's a very long shot. Justice Oliver Wendell Holmes Jr., famously called the Great Dissenter, fewer than 10% of his dissents ever became majority opinions later on.
Less than 10%.
Yeah. And think about Justice Benjamin Curtis's powerful dissent in the infamous Dred Scott case. Hugely important morally and historically, but it made little immediate legal difference. It took the Civil War and constitutional amendments to overturn Dred Scott.
So if they don't often change the law directly, why do they matter? Who are they even writing for?
Well, the sources suggest they probably aren't intended to change the minds of committed ideologues on the court or off it. Instead, their deeper significance, the enduring lesson perhaps, lies in the struggle itself. It's about, as one commentary puts it, trying to redeem the practices of reason-giving and fidelity to facts against a worldview in which those practices count for less and less.
So it's a defense of the process of law itself, of reasoned argument based on facts and precedent.
Exactly, trying to keep that tradition alive, even in dissent.
We've certainly covered a lot of ground here. We've navigated the evolving landscape of Supreme Court dissents, from those really quiet origins to today's very loud, very defiant pronouncements. We've seen how justices like Kagan, Sotomayor, and Jackson aren't just disagreeing on legal points anymore. According to the sources, they're sounding an alarm about the very nature of law and governance in America, even invoking a framework as sobering as the dual state.
And these writings, these dissents, they aren't just dense legal opinions meant only for other lawyers. The analysis suggests they're really a direct appeal to you, the public.
An appeal to recognize the stakes.
Yes, to recognize the profound stakes involved. They're asking us, asking you, to consider what happens when the highest court in the land, which is meant to be impartial, seems to be abandoning its own established norms and principles.
And just as Kagan herself has basically said, look, if the court won't return to finding common ground, won't abide by precedent, then she'll just, quote, spend a lot of my time dissenting.
A stark prospect.
It really is. And it raises, I think, a crucial question for you listening right now. How do you respond when the very foundations of law are being so openly debated and seemingly challenged from within the highest court itself? What responsibility does that place on us as citizens to actually engage with and try to understand these critical legal battles that are shaping the future of our